A story like this gets people fired up fast. Claims of a major H-1B visa scam operating out in the open in Texas, with people saying they are running companies from their homes and sponsoring dozens of workers. And the big question that comes next is the same one you asked. Why hasn't USCIS found it and stopped it already? Today, I'm going to break this down carefully, without hype, and with practical steps you can take right now if you are an H-1B worker, a student aiming for H-1B, or an employer who files petitions the right way and does not want to get swept into extra scrutiny. By the end of this video, you will know 3 things. 1. What an H-1B petition actually has to prove in plain English. 2. The red flags that separate a legitimate small or home-based business from a petition setup that can collapse. And 3. What to do right now to protect yourself, including a simple checklist you can save and use before you sign anything or transfer jobs. Here is the part most people miss. An H-1B scam does not only hurt the government. It hurts real workers who pay fees, uproot their lives, and then find out the job never existed. And it also hurts legitimate employers because when fraud patterns show up, scrutiny increases for everyone, and normal cases start getting RFEs, site visits, and delays. Now let's define what people are really talking about when they say H-1B scam. In most cases, the fraud is not a single trick. It is a chain. Someone creates or uses a company that looks real on paper. Then they file labor condition applications, or LCAs, through the Department of Labor, and then they file H-1B petitions with USCIS, claiming they have specialty occupation jobs available for specific workers at specific wages and at specific work sites. The scam usually depends on one of these being false. The job duties are fake. The employer-employee relationship is fake. The worksite is fake. The wage is not paid, or the company is not really operating the way it claims. And sometimes it is multiple at once. And before we go any further, I need to be very clear. A home-based company is not automatically fraud. A startup can be legitimate. A small consultancy can be legitimate. Remote work is real. Lots of small U.S. businesses are run from home, especially in tech, marketing, accounting, and services. The issue is not the home address. The issue is whether the employer is real, the job is real, the control is real, and the wage is real. So what actually changed, or what is changing, when these kinds of reports spread? Often, nothing changes in the law overnight. But what can change quickly is enforcement attention and adjudication behavior. That means more requests for evidence, more site visits, and more skepticism of certain patterns. And a small detail can change everything. The same petition that would have been approved smoothly last year could now get questioned if it matches a fraud pattern USCIS or the Department of Labor is tracking. Now, let's quickly break down what an H-1B petition must prove, in plain English. First, the job must be a specialty occupation. That generally means it normally requires at least a bachelor's degree in a specific field, and the job duties match that. Second, there must be a real employer-employee relationship. In simple terms, the company must have the right to hire you, pay you, supervise you, and if needed, fire you. Third, there must be a real wage and real compliance. The employer must pay at least the required wage listed on the LCA and keep the required records. Fourth, there must be a real work location plan. The petition should clearly describe where you will work, including if you are remote, hybrid, at a client site, or at multiple locations. Fifth, there must be a real business need and operational capacity. USCIS can question whether the company has enough work for you, enough revenue to pay you, and actual ongoing operations. This is where home-based companies can face extra questions, not because home equals fake, but because there is less visible infrastructure and it is easier for bad actors to hide. Now let's talk about who is affected and who usually is not, because this is where panic spreads, and panic leads to bad decisions. Group 1. Workers already on H-1B at stable employers with clear payroll records, a real office or clear remote policies, and normal job duties. You may see more questions in the system overall, but your case is usually not the main target, unless there is a pattern in your employer's filings or your role looks mismatched. Group 2. Students on OPT or STEM OPT working for small or new employers who are preparing for H-1B. You are affected in the sense that you should be more careful with documentation and more selective about employers who promise sponsorship with no interview, no real supervision, or unusual payment arrangements. Group 3. People being recruited into H-1B by third-party staffing or consulting arrangements. Some of these are legitimate, but these arrangements are historically higher scrutiny because USCIS wants to see who controls your work and whether the end client work is real. Group 4. Brand new companies with little revenue or minimal operations attempting to file multiple H-1Bs right away. Legitimate companies can grow fast, but filing dozens of H-1Bs from a residential address with thin evidence is exactly the kind of pattern that can trigger deeper review. Group 5. Employers who are doing everything correctly but happen to share characteristics with fraud patterns. Home office, remote team, consultancy, multiple work sites. These employers are not doing anything wrong, but they may need to front-load evidence because this is where people get delayed. Who is usually not affected? People applying for unrelated benefits, tourists, most family-based applicants, and many large employers with consistent compliance history. But there is a catch. If enforcement resources surge in one area, processing in adjacent categories can slow slightly. It is not guaranteed, but it happens. Now let's address the big question. Why hasn't USCIS already discovered and stopped it? There are a few practical reasons, and none of them require a conspiracy. 1. USCIS is not an investigative police agency in the way people imagine. They adjudicate petitions based on documents, and they do run fraud detection. But their system is designed to process very large volumes. Most petitions are paper-based evidence reviews. 2. Fraud is often discovered after patterns emerge. One suspicious petition may not prove anything, but when multiple filings show the same address, the same template letters, the same job descriptions, the same end client names, the same phone numbers, or the same petitioner behavior, that is when a pattern becomes actionable. 3. There are multiple agencies involved. The Department of Labor handles the LCA and wage and working condition framework. USCIS handles the immigration petition. Site visits can occur through USCIS fraud detection units. And serious criminal investigations, when they happen, can involve other law enforcement agencies. Coordination takes time. 4. Scammers exploit the time gap. They file, collect money, move addresses, rotate company names, and shift workers before the system catches up. 5. USCIS does discover and stop many of these, but you may not see it in real time. Some outcomes are quiet: denials, revocations, RFEs, and referrals. And some cases become public later through court filings or press releases. But that is after the fact. Here is the key. The question is not only whether USCIS knows. The question is what they can prove and what standard of evidence applies at the time of adjudication. And that brings us to the most important part for viewers: the red flags that trigger RFEs, site visits, denials, and sometimes worse. Let's go through the most common red flags. Number 1, a job offer that sounds too easy. No real interview, no technical questions, no clear manager, and they promise they can get you H-1B quickly if you pay. A real employer recruits because they need you, not because you are a ticket. Number 2, money flows the wrong way. If anyone asks you to pay the employer back for filing, pay for a job, pay for payroll, or route money through your own account to show wages, that is a giant warning sign. Number 3, vague job duties. If the petition package uses generic duties that could fit any job and does not match your degree, that is where people get denied. Number 4, no real client documentation in third-party placement situations. If you will work at an end client, USCIS often wants to see contracts, statements of work, and evidence of the itinerary and supervision. If the company cannot show it, that is a problem. Number 5, unrealistic headcount claims. A tiny company at a home address claiming to have dozens of employees with no public footprint, no projects, and no proof of operations. Again, not impossible, but it invites questions. Number 6, inconsistent addresses and worksites. The LCA says one location, the petition says another, your pay stubs show something else, and your LinkedIn says remote from a different state. Inconsistencies are where cases unravel. Number 7, benching or unpaid time. H-1B rules generally require the employer to pay the required wage, and prolonged unpaid periods can create serious compliance issues. Even if you did not cause it, it can still create risk. Number 8, the employer cannot describe supervision and control. If you ask who your manager is and what tools and process you will use, and they cannot answer, that is a problem. Myth versus reality moment. Number 1, myth. If a company has an LLC and a website, it is automatically a legitimate H-1B sponsor. Reality. Those are easy to create. Legitimacy is shown by operations, contracts, payroll ability, supervision, and a real specialty occupation role with a real need. Now, what about site visits? People hear the words site visit and panic. A site visit, when it happens, is basically USCIS or a fraud detection contractor verifying that the employer exists and the job described matches reality. They may verify the address, ask to speak to HR or a manager, and ask basic questions about the role, salary, and work location. If you work remotely, they may verify policies and supervision. For third-party placements, they may verify the end-client relationship. And here is the part most people miss. You do not need to treat a site visit like a raid, but you do need to take it seriously. Employers should have consistent records. Workers should know their job title, manager, work location arrangements, and basic duties. If you cannot explain your role, that alone can trigger questions, even if you are legitimate. Now let's make this concrete with an example scenario. This is a composite example, not a statement about any specific person. Example scenario 1. A student on OPT gets a message on social media from a recruiter offering an H-1B. The recruiter says the company is in Texas and can sponsor many people, and the student can work remotely from anywhere. The student is told to sign an offer letter quickly and pay a placement fee. They are also told not to worry about the project because the company will figure it out later. The student does it because time is short. Then the petition gets an RFE asking for detailed job duties, worksite, and proof of actual work. The company responds with generic letters. USCIS denies. Now, the student is out of status planning time and the money is gone. The takeaway is not that remote work is bad. The takeaway is that a real job has real work details, real supervision, and no pay to play. Example scenario 2. A legitimate small startup is actually run from a founder's home. They have real revenue and real clients, but they are new to H-1B. They file for an engineer. Because of increased fraud attention, they get an RFE asking for proof of specialty occupation, proof of the company's ability to pay, organizational chart, contracts, and a detailed remote work plan. The startup panics because they think home address equals denial, but they respond with strong evidence: client invoices, bank statements, payroll plan, detailed duty breakdown, manager oversight plan, and a clear LCA work location strategy. The case gets approved. The takeaway: home-based is not disqualifying, but documentation matters more. Here is the bridge hook. Two groups are at highest risk right now, and they are not always the groups you think. First, workers who are tempted into arrangements that are really just paper sponsorship. Second, legitimate small employers who do not realize how much evidence they need to include and who respond too casually to an RFE. Now, let's get into what to do now in a practical do this and avoid this format. Do this. Verify the employer is real beyond a website. Ask for a clear job description tied to your degree, a manager name, and a day-to-day duty breakdown. Do this. Ask where the work will be performed and how it will be documented. If remote, ask for the remote policy and supervision plan. Do this. Ask how payroll will work, what the wage will be, and when you will start getting paid. Keep pay stubs, offer letters, and employment agreements organized. Do this. For third-party placement, ask what end client documentation exists and whether there is a statement of work, contract, or itinerary. Do this. Keep your own records consistent. Your resume, LinkedIn, pay stubs, work address, and petition details should not contradict each other. Avoid this. Paying for a job, paying a recruiter under the table for sponsorship, or agreeing to any arrangement where money moves from you to the employer to make the petition happen. Avoid this. Signing blank or generic letters that you did not read, or allowing someone to write duties that do not match what you do. Avoid this. Ignoring an RFE deadline or letting an employer respond with sloppy evidence. If you are the worker, you cannot control everything, but you can ask questions, and you can choose not to participate in something that feels off. Avoid this. Traveling internationally if your situation is unstable, your status is close to expiring, or there are unresolved issues. Travel can be fine, but it adds complexity. If you are in a gray area, get clarity first. Now, if you are an employer watching, here are safe steps that matter immediately. Do this. Make sure your LCA location and your actual work arrangement align, especially for remote workers or multi-state teams. Do this. Keep a clean public footprint and internal compliance files, including payroll capability and role documentation. Do this. Be ready for a site visit. Train whoever answers the door or the phone to route to the right person. Have a basic packet ready that matches what was filed. Avoid this. Filing multiple petitions with copy-paste job duties or unclear work sites. Avoid this. Filing for roles that do not clearly require a specialized degree. Now, myth versus reality moment number 2. Myth: USCIS never checks, so scams are easy. Reality: checks happen, but often later, and consequences can hit fast once a pattern is identified. Denials and revocations can occur, and if there is proven fraud, it can create immigration consequences for individuals too. That is why avoiding questionable arrangements is not just about ethics, it is self-protection. Myth versus reality moment number 3. Myth. Remote work means you can put any worksite address on the paperwork. Reality. Remote work still needs a compliant work location plan, and the LCA and petition details must be consistent with where the work is actually performed. The details matter. Now, let's circle back to the Texas angle. When a particular state, city, or cluster of addresses becomes part of a viral story, people start assuming the geography itself is the issue. Here is the reality. Fraud can happen in any state. The reason a cluster shows up is usually because of networks, recruiters, shared addresses, shared templates, and shared pipelines. If there is a cluster, it can become easier for investigators to detect patterns. That can lead to a burst of RFEs or site visits for cases that look similar, even if some are legitimate. And this is where people get blindsided. Even if you did nothing wrong, a petition can still be delayed or questioned if your employer matches a known pattern. So what could happen next? Here are the watch points to keep an eye on over the next weeks and months. 1. More RFEs asking for employer-employee relationship proof, specialty occupation details, and worksite specifics. 2. Increased site visits, especially for home-based employers and third-party placement arrangements. 3. More scrutiny of companies filing unusually high numbers of petitions relative to their size. 4. Possible public enforcement actions later, including audits, debarments, or criminal cases, but only if investigations develop evidence. We cannot assume that will happen in any particular story, but it is a normal enforcement pathway. 5. Processing slowdowns for certain patterns, not necessarily the entire H-1B category, but certain case types. Here is the part most people miss. The safest move is not to wait for headlines. The safest move is to make sure your own paper trail makes sense today. That is what keeps you out of trouble, even when the environment gets more intense. Now, if you are currently in an H-1B process and you are worried, here are 2 short "if you are in X group, do Y" segments. If you are a student on OPT considering an H-1B sponsor, do a basic due diligence check before you accept. Ask for a manager call, ask for real project details, and do not accept any pay-to-play arrangement. If something feels secretive, walk away. If you are already on H-1B and someone offers you a fast transfer with minimal questions, slow down and verify. Ask who will supervise you, where you will work, and how wages will be paid. A rushed transfer into a shaky employer can create bigger risk than staying put for a little longer. Now let's answer the emotional core of this story. Why would someone do this, and why do people fall for it? Because the H-1B system is high pressure. Deadlines are real. People fear losing status. Employers need talent. Bad actors exploit that pressure. They sell certainty in a process that is never guaranteed. And anytime someone sells you certainty, especially in immigration, you should pause. Before we wrap up, one more practical tip: know your sources. If you see a claim that a specific company is running a scam, do not rely only on viral posts. Look for verifiable indicators, official agency statements, court filings, reputable investigative reporting, or documented patterns. Avoid doxing and harassment. If you have information about fraud, there are official ways to report it, but do it responsibly and safely, especially if you are a worker who could be exposed. Now, let's do a calm recap so you leave with clarity, not anxiety. Number 1. A home-based company can be legitimate, but it often faces more questions because the system looks for proof of real operations, real control, and real wages. Number 2. Scams usually involve fake jobs, fake work sites, fake supervision, or improper money arrangements. The red flags are consistent: pay-to-play, vague duties, no real manager, and inconsistent documentation. Number 3. USCIS may not stop a pattern instantly because detection often depends on patterns, evidence standards, and coordination across agencies. Number 4. Workers can protect themselves by asking basic verification questions, refusing questionable payment arrangements, and keeping their own story and records consistent. Number 5. Legitimate employers can reduce risk by aligning the LCA with the real work plan, documenting supervision, and preparing for RFEs and site visits. If you want, tell me in the comments which situation you are in. Student on OPT, current H-1B, employer or family member trying to help someone. And if you have a specific question like remote work address rules, what an RFE usually asks for, or what to do before an H-1B transfer, drop it below. If this video helped, subscribe and turn on notifications, because when enforcement patterns shift, the first people who get hurt are the ones who hear about it last.